Alder, can I ask you about the news today around Coutts Bank and the apparent debanking of Nigel Farage? And there are other cases as well we could bring in. You may be aware of Coutts' response today, which has been to say that there are three reasons that they might terminate a relationship with a client. One is commercial viability, the other is reputational consideration, and the third is legal and regulatory requirements. You, as responsible for the legal and regulatory regime that banks operate under, are you aware of anything that the FCA might be imposing on Coutts or other banks that would cause them to terminate a relationship with somebody like Nigel Farage?
We are imposing something on banks.
Are you aware that might there be any legal or regulatory requirements that could explain why Coutts has decided to debank?
Not that I'm aware
Farage? Okay. So, nor am I. So the suggestion, therefore, is that it's either commercial viability or reputational considerations. And it seems to be apparent from the subject access request that Mr. Farage extracted that, although there was a query over his mortgage, his other bank accounts, the accounts he held, met the commercial viability requirement. So it seems apparent, and it is indeed explicit in the documents, that the issue is the reputational issue. And indeed, they say quite clearly that Mr. Farage is at odds with the inclusive organisation that Coutts aspires to be, and so it's clearly an objection to his political views and his activities. Do you think that that's acceptable?
Well, I think for banks as well as other commercial enterprises, it's fundamentally up to them to choose who they do business with. However, for FCA-regulated firms, they must treat people fairly. Reputational considerations about who you take on as a customer are frequently cited in financial services industry, across investment banks right through to retail. That's really as much as I can say right now. Not least from a board perspective, we have not considered this not least because it's relatively new in the press.
No. Well, it's been in the press for a little while now. And sorry, just to push you. I mean, you're suggesting, Mr. Alder, that it's up to the banks to decide who they do business with. Is that your position? Do you think it should be acceptable for a bank to terminate a relationship on the grounds of the client's political views? Mr. Alder.
I think it boils down to, the obligation of banks is to treat their customers and their relationships fairly. I'm not aware of anything in the FCA rule book that goes to the point around how banks judge their own attitude to reputational risk, if that's what it comes down to from their perspective.
If I could add specifically here, because there are different issues that are brought up here. There's one issue about politically exposed persons, where we will be doing a review following the legislation and to make sure that those rules are being applied proportionately by banks. There are important reasons for those rules because of the potential elevated risks and the international standards that have been transposed in the UK. But that's one set of issues. The next set of issues is specifically, as has entered the public domain recently, around freedom of speech and political views. I wouldn't comment on a specific case. Anybody who feels that their bank has not treated them fairly can go to the Financial Ombudsman Service, and the Ombudsman Service will look at the information the bank provides, what the customer provides, and can direct the bank to reopen an account or keep an account open if they feel that a customer is being unfairly treated. The payment accounts regulations in the UK, which are transposed from the European Union laws, there's a specific sort of definition around payment accounts, but if I give you the general position, you're not able to discriminate on the basis of protected characteristics. You're not able to discriminate on the basis of political views either. So that's in the legislation.
Indeed. So thank you very much. So given that, Mr. Rahel, what do you think, Nigel, what do you think is the obligation on the FCA to regulate this bank in particular, if it appears that, as it does appear from the paperwork we've seen, but further investigations no doubt are possible, if it does appear that they have contravened that rule about discriminating on the basis of political opinion, what can you do as the FCA, under your current powers, to regulate the conduct of this bank, or do you need further powers in order to intervene, or do you not think there should be any intervention from the FCA?
So, you'd expect that we are talking to NatWest Group about this. A specific adjudication on an individual case is a matter for the Financial Ombudsman Service. So the Financial Ombudsman Service would investigate what an individual has to say, and of course what the bank has to say, and would make a judgment in light of all of the data, because at the moment it's difficult to comment on excerpts that have been released in the press. There may be other materials that would be considered by the Ombudsman, whether the decision has been a fair decision, compliant with our rules, and if it's not, what the action should be that should be taken. If a complaint is made and it is determined that there has not been appropriate consideration of this case, that would then of course be relevant for us from a supervisory perspective.
You are in conversations with NatWest, and you regard discrimination on the basis purely of political views to be in contravention of the rules and indeed the law.
The law is clear.
Thank you. What do you think about the action of Coutts Bank in what appears to be a deliberate leak of confidential information about Mr. Farage's finances to the BBC? Are you aware of that? And would you take steps in response?
I've seen the media reporting on it, and obviously I'm not able to respond to specific allegations, but I think the allegation is that there's been a breach of data protection rules. That's obviously a matter for the Information Commissioner, because we regulate separate areas, but we would obviously be concerned if there'd been any breach of data protection rules.
Okay. So moving on to another very similar case, there's a vicar called Richard Fothergill who responded to an inquiry from his bank, Yorkshire Building Society, for general feedback, and he responded that he wasn't very happy about their endorsement of the Pride Month, and was immediately terminated. His banking relationship was immediately terminated. If that's all the information there is, there might have been other information. Let's assume he wasn't abusive or offensive in his communication. If that was his only offence, do you think that's legitimate grounds for termination of an account?
I'm very reluctant to speak about individual cases. These are sensitive cases about individuals' banking relationships. The rules are clear. There may be commercial reasons for shutting an account, in which case you should give 2 months notice. We would say, particularly under the new consumer duty, a good clear explanation should be provided. It may be the case, particularly if there are financial crime concerns or other concerns, an explanation is not provided, and that's legitimate too, because we wouldn't expect a bank to reveal any intelligence they've had of illicit activity. Banks are able to shut accounts at shorter notice where they consider, for example, the behaviour of the customer is abusive to their staff, and we saw quite a bit of that during COVID in terms of aggression towards branch staff. I won't go any further than that in terms of commenting on this
I doubt
case.
that the Reverend Fothergill was abusive, and let's assume he wasn't, nor that there's criminality going on. So it does seem to be he had his account closed just because he expressed a political view. So